what really happens through a bankruptcy. And I'm here with Larry Friedman, who was the former director of all bankruptcy attorneys nationwide. Okay, so he was the guy that created policy and pushed it down to the tens of thousands of bankruptcy attorneys nationwide. I'm going to throw some fastballs at you, and I want quick answers. Okay. Number one, someone raised their hand and says, I want to file bankruptcy. Is my employer going to find out that I filed bankruptcy?
Well, it depends. In some cases, Phil, there's a wage garnishment in effect.
Mhm.
So, yes, they're going to know that you filed bankruptcy because it's going to release the wage garnishment. But
So
if they're
what you
not,
mean by that is if someone is already getting their wages garnished by a
yes,
collector, when you file bankruptcy, that's going to release it so you keep the money,
that's right. But
right?
that shouldn't be a problem for anybody. I mean, you're fixing the problem. And the
As,
employer
as a
the
as a
employer already knows that you were garnished.
as a
So,
director of all bankruptcy attorneys that you pass down case law, how often have you heard of employers firing someone because they filed bankruptcy?
well, I think that would be a problem. And I'm
Okay.
not familiar with any instance of that, but if that were to happen, I think you'd have a cause of action against the employer.
So you're saying if an employer fired you because you filed bankruptcy, you could sue the employer.
Maybe in
Maybe.
some
Okay.
states,
In
sure.
some, okay. Next thing. What about my family? Is my family going to know I filed bankruptcy?
If you owe your family money, they're going to find out because you're supposed to list everyone that you owe money to on your bankruptcy petition. So, yes. And you need to have, I mean, if you're borrowing money from family, you need to have a straightforward conversation with the family member saying, this is what I'm going to do. I'm going to file bankruptcy, and that debt is going to be discharged. Now, that doesn't prevent someone from voluntarily repaying a family member.
Right.
The problem comes up where they don't disclose that they borrowed money from a family member. And then before they file bankruptcy, they've paid some money back to the family member because they don't want the family member included in the bankruptcy.
Mhm.
So they get like $1,000 payment or something and they make that one. That's a preference claim. You've
Right.
preferred that creditor
Right.
over, right, over your other creditors, and the trustee could recover that money.
But that's assuming you owe a family member money. If you don't owe a family member money,
There's
what
no
are the
reason for them
chances?
to find, there's no reason to find for them to find out whatsoever that you filed bankruptcy.
Now, bankruptcy is public. Everyone thinks you can search the internet and say, has Larry Friedman or has Philip Tyrone filed bankruptcy? How easy is that?
Yeah, it's not as easy as you think. I mean, for one, if you really wanted to confirm whether they filed bankruptcy, you'd need to look on Pacers. You'd need a Pacer account to be able to look that
So you
up.
need to find that. First of all, know the website. Second of all, you need to create an account. Third of all, after a certain amount of searches, they charge you for that,
They
right?
charge you every search.
And every and the other thing is it's not that easy. It's not. It's a government run website as you would imagine it. It's not like Googling, right?
You're right.
It's complicated.
It is.
Yeah.
Now, if someone is running a credit check on you,
Mhm.
they're going to see the bankruptcy because these are reported to the bureaus.
Yeah. Right.
But so if you're applying for an apartment, someone's going to know that you filed bankruptcy. The best thing for debtors to do is to just be forthright with it.
Yeah.
Deal with the issue.
Yeah.
Don't try to hide or find a workaround for your issue.
Mhm.
Confront your issue.
Yeah.
That's the best in everything in life, quite frankly.
Larry, one time we were talking, having a conversation about debt settlement, debt negotiation, debt validation, all this debt stuff, right? And you've seen it all in your years, right?
Hmm.
And you were like, there's no other solution that is as good as bankruptcy, not even close. And you're so like over the top with it that it would like imprinted on me. I'm like, man, he's like I'm a fan of bankruptcy, but this guy's like all in on bankruptcy. Speak into that. Like as
So I
opposed,
used to, at the
yeah,
beginning of my 341 hearings, I'm talking to debtors
as a trustee. You were
as
a
a
trustee
trustee,
for
and I'm
chapter.
administering their case.
Mhm.
And debtors are nervous and apprehensive, and I mean, they don't get that it's a simple process.
Mhm.
They're going into somebody who's got the seal of justice behind them. They're sitting on a bench. They're obviously controlling the situation. And the trustee is saying things like, if you lie, this could be a criminal issue.
Right.
And they're like freaking out, right?
Yeah.
I used to say it this way: everybody has bad days. This is not a good day for you. You're probably feeling apprehensive about it. You're probably embarrassed. You're probably scared. You're probably nervous. I get all that. It's not my job to sit here and judge why you're here. That's
Mhm.
not my job. My
Mhm.
job is to make sure that everything you've done complies with the code so you can get the relief that you're seeking.
Mhm.
I don't judge you, and nobody in this room is going to judge you for what you did.
Mhm.
So if you've done everything right and you've read this information and you understand it and you answer the questions truthfully, from everything that appears on my side, you should get a discharge. And if there's no assets, I'll file a no asset report and you go on your way. The problem comes up when you are afraid, and so you don't speak to the thing you're afraid of, and you
Yeah.
hide something.
Yeah.
Because then, as bad as this day is for the debtor, it's not as bad as the day that they find out about 18 USC 152, the criminal section of the bankruptcy
Yeah.
code. That's a bad day.
Yeah. That's a
When you start talking about your
real bad
freedom,
day.
that's a bad day.
Yeah. So
Right now, it's just your finances. We can fix that.
what you're saying is come clean with your debtor attorney, your bankruptcy attorney,
Just
and
face reality.
bring up the elephant in the room. Bring up like what you're worried about.
Confront your fears.
Yeah. Yeah.
Yeah. Yeah.
Okay.
You'll feel so much better. You'll sleep so much better. The day you do that and the trustee says, great, I'm going to sign off and you're going to get a discharge 90 days from today,
Yeah.
you'll sleep like a baby.
Larry,
It'll be the best day. It'll be the best day of your life.
when you were in charge and the director of the bankruptcy program and passing down all this law across the country, right? Like the amount of relief you were giving, like literally to hundreds of thousands of debtors, like what had to be moving. Like, did you ever like have any story around that? Anything that's just sort of like, wow, I remember this or I remember that.
Well, every debtor who gets relief, I mean, 92% or 93% of Chapter 7 cases are no asset cases. So
And what does
every
that
one of
mean? What
those,
does that mean?
it means that by reviewing the papers that you filed and by cross-examining you really, but questioning you about the papers you filed, and by doing some investigation, and I had my own ways of doing that, I've determined that there are no assets available to be liquidated to pay your creditors.
Mhm. Right.
And when I do that, I file a TDR, they call it a trustee no distribution report. And when that happens, usually shortly after the 341 hearing, then the discharge is automatically entered 90 days from the date of the first scheduled 341 hearing, unless you don't do the post-petition education course.
Got it. And that means when you put that TDR in, they owe zero to the creditors. And 92% of the time, that's the case.
They don't owe zero. It means that they're going to get a federal court injunction
Mhm.
enjoining any creditor from trying to collect the money from them.
And the creditor can never go after them.
Never.
And if they do, the client should know this, they can be
Oh yeah.
sued. It's illegal to go after it. And they may still go after it. But if they do, put a note in the comments or comment on this, and we will introduce you to an attorney that
Yeah.
manages this.
The sanctions are big for that, Bill.
Huge, huge.
Huge.
It's horrible, but the creditors do this. This is a way to get back at creditors, frankly, when they do it, and actually you can make money at it. So that's a
Yes.
whole nother conversation, Larry.
Yeah, that is.
Larry Friedman, former director of the U.S. Bankruptcy Program. Larry, thanks for joining.